Hello and welcome everyone to the Maine Event this week. I'm Meeta, Sahni, and I'm really pleased to be joined today by our special guest, employment lawyer Emma Griffiths of Draper Lang. Hi Emma, how are you doing?
Hi Meeta, very well, loving the sunshine. How are you?
And you're looking very sunny with your look, and I'm still kind of rocking winter over here. So really good in the office, and just while everyone's sort of jumping in, I thought I'd mention that for the first time couldn't get a seat on the train, and it's showing a lot about the new rhythm that people have adopted and adapted post pandemic, and that's what we're talking about today, isn't it? Really?
Yeah, absolutely. And I went in to London yesterday. Yeah, I think it was yesterday, day before, and I found it really interesting. On my train journey in, everybody was wearing a mask. On my train journey home, barely anybody was. So I don't know if, and it's the same line, same journey, same people, presumably. So I don't know if there's a mindset shift as the day goes on, that people become more relaxed
or maybe it's location, because from Purley into London, nobody had a mask on this morning, and it was jam packed. And it's an interesting one, and I think that's what we're talking about today. So for the next 30 or 40 minutes, Emma and I are going to be talking around everything legal when it comes to getting your people back to work, whether it's hybrid, whether it's 1 day a week, whether it's full time. Ultimately, it's the same set of challenges, albeit for different amounts of time, depending on your setup. But there are so many implications, aren't there, now that restrictions have been lifted, Emma?
Well, there's so much to think about, I think, because the new Living with COVID plan is coming in, and the 1st of April is coming up as another key date as part of that plan. So we've already lost the legal requirement to wear masks and to self-isolate. And now we're coming up to the big one, really, which is the removal of testing. You know, there's no longer going to be free access to testing. So there's a lot of questions for employers to think about.
There really is, because in a way, having the government sort of stipulate rules and think, structure to keep us safe, that's all being pushed to the employer now, isn't it? It feels as though, you've got the majority, as you said, no masks, or later in the day, more relaxed. And, the majority seem to be wanting to just get on with it. But actually, there's a contingent, and a growing contingent, because of the rising cases again. People don't feel safe again. And I know personally, I haven't worn a mask in a very long time. My husband and son have COVID. I wore a mask today. So it's difficult, because no two people are the same in this. I think that's what blanket rules may not fit all.
And I think that's it. There were never, no two people were ever the same, but the rules were the same and they applied universally. And now no two employers are the same as well, because everybody has, and there's a recognition, every workplace has different pressures, has different people. Those different people have different concerns in terms of whether they're vulnerable physically, whether they're vulnerable mentally, whether they have another reason they might not want to wear a mask, or whatever that may be. So there's a lot now for employers to take in. And some of the things I think we said we'd talk about today is, how do you deal with now that refusal to return to work, the health and safety concerns that are coming forward, people refusing to wear their masks, and also what do you do with isolation if somebody's exhibiting COVID symptoms?
Yeah, even if they don't have to test, how do you deal with that? And, we've actually, as always, our sessions are interactive. We have a chat box on the right that Emma and I have already been having a little play around with. So I'm just going to say a hello in here. It's that easy for you to share your comments, your thoughts or questions. Please share. The more direction you give us on what you want us to answer for you today, hopefully the more knowledge and expertise you can walk away from this session with. We try to keep them 30 to 40 minutes. We know time is really precious, but we hope that this little nugget of insight and understanding of not just laws or lack of laws now, but actually what's going on in other organizations and how companies are dealing with these challenges. Hopefully that will be useful to you. We also have a poll that we would really appreciate your input into. So this will help us understand what the challenges are, and also design future webinars for you. So our question today is, what challenges are you facing in the workplace now that restrictions have been lifted? Well, most restrictions, as you've mentioned, Emma, some will be going in April. So first one is health and safety concerns at the office. Second is isolation, mask issues. Third is managing people and performance. And finally, mental health and well-being. And interestingly, at the moment, health and safety concerns and mental health and well-being are flying ahead. So I think that's the challenge. All of these areas and issues, you know, the factors that they reflect into people's psyche. There, as I said, I felt different today coming in. So yeah, it'd be really helpful to get your thoughts on there, everyone, while we're running through, and we'll share the results at the end of the session.
It's really interesting looking at those two coming through as the theme. Absolutely. Yeah. To see if it stays the same towards the end.
Indeed. So Emma, where do we start? I mean, we've you know, mask restrictions have been lifted, isolation has been lifted. What else is, so there's something else coming in April. Tell me where we are with that.
Free testing's disappearing. So a couple of key things from April is the working safely guidance that the government has produced is being replaced with new public health guidance. So really important for employers to, as I think have been regularly throughout the pandemic, get a handle on what the guidance is, make sure they're following it. Predominantly, it will be things we're all very familiar with in terms of hygiene, in terms of ventilation, but important to keep on track of that. There has been a legal requirement to explicitly consider COVID in health and safety risk assessments. That's been a mandatory requirement. That's actually being lifted. Unless you work in a sector where you're using COVID. So, for example, people in science labs that are testing for COVID, they need to. But aside from that, that's going. I would suggest that employers continue to expressly consider COVID for now. As we know, the cases are going up hugely at the moment, actually. And I think with no masks, no testing, and as you say, a more free attitude, I think generally, I think that's going to continue. So that's important. But the big one that's going is unlimited free test. Well, the COVID pass is going, but I haven't seen much use of that recently, to be fair. But the big one is the unlimited free testing, because what was happening prior to this is somebody exhibited the COVID symptoms. Employer would get them to do a lateral flow test or ask them to remain at home. Now, access to those lateral flows is going. So for a short time, there'll be a little stock, won't there, in people's homes, and then you have a question mark.
And it might be a cost that the employer has to bear to keep their employees safe. It's just the unknown again. It feels a little bit like 2 years ago, almost to the date, where we're, you know, set with a whole new set of challenges. And how should we as employers continue to be able to function as an organisation, keep our people happy, safe and well and able to do their job, and not have any cases thrown at us because we haven't done it right. So where do you think this is going? I know I thought we'd cover a little bit about case law, just because a lot of people watching will either have their own cases ongoing or want to ensure that they're not one of the statistics of future case law. What would you what has the journey of case law been over the pandemic?
So I had to look back over the cases because, as I think most people on this call probably know, employment tribunal process is not quick. So cases that I'm getting in, land on my desk now are not being listed for 12, 18, 24 months. So the case law that's been coming through in the last 6 months, year, has been related to what happened right at the very start of the pandemic. Okay. So almost some of those cases are, when employers thought that COVID was a bit of a fuss about the flu and people were raising concerns and being dismissed. So, or the cases relate to questions around redundancy and furlough. And should you have made somebody redundant when furlough was an option? Now, those sort of things, I think they're so time specific and fact specific. They're not going to lead us anywhere now. So it's a whole new raft of case law. So I think a whole new raft of case law is being developed now. So I think the important thing for employers is to focus on what their legal duties are. And this is the theme that runs through cases that are coming out now. You've obviously got the implied duty of trust and confidence. So you have to act reasonably in any situation. You also want to you also need to make sure that you stick to your duty to protect the health and safety of workers. Very important. Question about how to do that with the guidance as it is at the moment. And then also you want to avoid discrimination, so indirect discrimination. And I think on the last webinar we talked a lot about talking to employees and the importance of communication. And that is absolutely the thread that runs through all of this now. If you've got somebody that's refusing to return to work, for example, because they feel unsafe, or, you know, for whatever reason they're refusing, the key is to engage and speak to them, because the most common reasons people are not wanting to come back to the work at the moment, one is anxiety, health-related anxiety, and that may be nothing physical or no particular concern they have, but they are anxious about the COVID situation.
Yeah.
Maybe a physical health vulnerability of themselves or a family member, and they're trying to keep themselves clear. And then there's the third, I just don't want to. I've quite enjoyed working from home. I don't really want to come back in.
Yeah.
So I think
people are talking with their feet in that space, you know, in fact, in all spaces, if they don't feel that the employer has engaged fairly and collaboratively, people are choosing to leave. You know, the demand on talent and the number of roles out there per person, you know, they're sort of 10 times where they were a year ago, you know. So it's really important if you want to, you know, I'm a big believer, it's all very well we bring people in, but then to actually retain them and develop them and get the best out of them and the best for them, it requires a plan that you're both on and staying in parallel. But Emma, what you said about a duty of care, but then all of these restrictions and requirements being lifted, it feels almost like people are being, it feels like case law waiting to happen, really, no? What if somebody...
I think you're right. Yeah, absolutely. And I think there was some employers recently got fairly bad press for suggesting that employees should come in if they've got COVID symptoms, because isolation has gone away. So there was a suggestion that they should come back in. And if you are suggesting that somebody's got COVID symptoms and you encourage them back into the workplace, well, then you're not necessarily protecting the health and safety of the colleagues around, are you? So I think best practice is, if somebody has COVID symptoms, if you can access a test or get a test for them, then that's a sensible approach. I think Boots are selling them for about £6, but quite quickly across the workforce that can stack up. I think for now we've got the cushion of there being, most people have got some tests hanging around somewhere or access to them. So I think, go on.
I'm sorry, I was just going to say, I think it's a cost that employers are going to have to bear for a while, because until we get more clarity and more a period of time, you know, where we are beyond the pandemic, that, you know, people won't feel safe. And it's interesting, the poll at the moment continues to be, the challenges are mental health and wellbeing at 60%, and then health and safety concerns at the office at 40%, potentially linked.
Oh, you know? Absolutely. The anxiety about returning to work. But then also I think mental health concerns are such a bigger issue in the last 2 years. One, I think, again, as time goes on, we're all more aware, we're all more able to speak and recognize and highlight mental health concerns, and that's a massive positive. Also, everyone knows the pandemic has had such a fundamental effect on people's health and well-being. So it's a wider question than just the return to the office, but absolutely that anxiety and that fear about returning to work is very real. And that's where it is those discussions that, you know, you may have your blanket policy about wanting people to return however many days a week that may be. But imposing that blanket policy on everybody without stopping to consider everybody's individual situation puts you as an employer at risk.
So how would an employer word their health and safety policy around COVID? Would the language be not "you are required," but "we intend to"? Like, how would employers word it?
I think the health and safety policy is a different point. I think it's the return to work policy and I think you would be saying that we intend to have people back, or we would like people to come back. And in some places we require people to come back. But the point being is, you have that point on there that says, if you have any concerns about this, come and talk to us. And that needs to not just be lip service, to actually have that discussion about why. Because one, you have the duty of trust and confidence. So if somebody has got 2 years service and you're not, you know, taking their concerns seriously, they might claim unfair dismissal. Two, you might be indirectly discriminating against somebody, because, for example, somebody that may suffer with anxiety to the point that it's a disability, you have an obligation to put in place reasonable adjustments. Those adjustments might be to continue home working to a point. Those adjustments may also be perhaps to consider avoiding travel at peak times. You know, as you said this morning, the train was packed, nobody was mask wearing. Well, that person might like to start a whole lot earlier in the day and avoid that packed train, or arrive later and finish later. And it's engaging sensibly with each person to see where you can get to. the I don't want to come back, having explored is there a health concern? Is there something that, is there something deeper? Is there an indirect discrimination? Because actually the home working works better for your childcare. Once you've gone through all of those layers, the I don't want to come back in itself isn't necessarily good enough. And you come to a point where employers can insist and say, no, you need to come back. And that's where you say that there's a choice as to whether somebody votes with their feet or not.
Yeah. And it's interesting that managing people and performance hasn't featured on this poll, which suggests that actually people are able to do their job. I've just got a comment actually from Yvonne. Hi, Yvonne. So Yvonne says the post holder is required for business purposes 1 day a week, but refused and is now saying they are too anxious to come in. Okay. However, there is no medical information to back this. How can an employer proceed if occupational health and stress risk assessment does not back making this alteration to work? That sums up our whole, it's a really good question, Yvonne, thank you, and will hopefully allow us to share some of the insights that Emma has today.
Yeah, thank you for the question. That is an interesting one. I think the key is when you say there's no medical evidence to back this up, and the question is how deep have you dug for that in terms of have it sounds like they've gone to occupational health to see what occupational health have to say, and that's really valuable and really useful. It's also helpful to go to the employee's own doctor and actually say to their get consent from the employee to go to their treating doctor to understand if there's a condition, because they will know that person best and you can consider adjustments from there. If in the unlikely event their doctor says no, they haven't got a condition, there's nothing to do, then you're taking a view, aren't you, in terms of the risks around that. And if there is not the disability discrimination risk, then you might be at a point where it's a reasonable management instruction to return. I think the other question is, why are they anxious to come back in? Is there something about the workplace specifically that is making them anxious? And there is also, I've talked about reasonableness and trust and confidence and discrimination. It's also important to remember that employees have the right not to be treated to a detriment or discriminated against, treated to a detriment or dismissed for raising health and safety concerns. And there is various case law that has come through where somebody has raised a health and safety concern. I can't come back to the office, it's not safe because the employer is not doing X, Y, Z. They've ultimately been dismissed, and those dismissals have been found to be unfair and also automatically unfair because they were linked to the health and safety concern. So it's, as well as the medical point, what is it about the office that is making them anxious, and making sure that you are complying with all of the required guidance to make sure that it is actually safe for them to return.
That's a really good point, Emma. It's the making notes, confirming that you've done all these checks, whether it's by email or the health and safety policies are sent out regularly when they're updated, and getting people to sign to say they've, and maybe even asking people, have a read, any questions, like everyone happy? Can organizations do that so that people embrace?
Yeah, once you're over a certain size, your health and safety policy ought to have been done in consultation anyway with employees. So absolutely. I knew you'd ask me that. I think it's over 50 employees, but I wouldn't swear to it. But yeah, consultation is brilliant because bringing people with you is the way forward. But ultimately, having done that, having established that the dismissal is not because of a health and safety concern, having established that you have done everything that you have to do in terms of health and safety, having established that there isn't a medical need and that there's no reasonable adjustments, then you are at a point of you say, well, okay, are we going to accept this person not coming in or not? And if you're not, then it's potential disciplinary stuff for failure to follow a reasonable management instruction. But what I would say is everything is so fact specific. Every single case on this turns on what, when, how, because, as we touched on at the start, every employer is different, every workplace is different, every employee is different.
Yeah.
So you've got to be really, really thorough, and if you can take specific advice before you're moving to a dismissal because of this, it's really sensible to do so, because it's so it all turns on its own facts, and you've got to be sure that you're not leaving yourself vulnerable.
Yeah, and Yvonne, if you have more questions, Emma, I know you make yourself available outside.
Yeah, absolutely. Be more than happy to have a chat.
Perfect. Well, Yvonne, let us know if you'd like to connect with Emma outside of today's session.
Answered your question, though, at least been a wider help to the group.
Indeed. Well, it's really, as you said, Emma, it's a process of, it's not a tick list, but it is a checklist, if you like, of we've looked into this, we've looked into that, as you said, consult, get feedback, and then ultimately, I think I would also add, from where I'm sitting, I would look at why you need them in 1 day a week. And I understand a lot about culture, about if one person says they don't want to come in, other people might start saying that. But actually, in the main, a lot of people are really happy with the hybrid approach. And 1 day a week isn't, an unfair demand of people's time, away from home. So it may be that, you decide to say to them, look, having done all of that and then still saying no, measure their output, make sure their job description looks clearly at what the expectation is of what good looks like, and say, okay, why don't we try it for a month and then we'll revisit it. Then not only will you have done all the sort of health and safety requirements, but before you were to put them onto some sort of disciplinary track, you can demonstrate that you actually allowed them the time to show that it can be done. But I understand there's more layers than that. It's not as black and white as that. But I think in this day and age, productivity hasn't been impacted. I think culture has. And I think, especially for new people, what we're finding is that for new people joining companies, by them not going in, there's less connection and commitment, and therefore they leave more easily. And that's really hard. I mean, we're in the business of helping businesses find great people and then retain them. And so the hardest part is when somebody doesn't feel connected and chooses to step off that train. It's it's futile for everyone, and it's very wasteful. So think about, you might even have different policies for different people, is what I'm saying about coming into the office.
Yeah, and the culture is such a big piece. You're absolutely right. But of itself, it's not necessarily enough reason not to make an exception for one person, if there is a good reason to make an exception for that person. And you're spot on in terms of, do you need to do it? And really drilling down into the analysis and being sure about that. Plus the fact that everything has changed so much over the last 2 years in terms of, we're in, we're out, COVID's high, COVID's low, where we might be with that. And I think employers are starting now to make more hard and fast rules and policies. Again, you, as you say, keep it under review for the summer, revisit it at the winter, see where you go.
And always have a business case. Always make sure that you have a business case. Okay, we have another question for you, Emma. Joe asks, hi, Joe. Can you go back to the childcare issues, please? We have a number of employees now who have said they are having childcare issues and need to work from home to pick up their kids from nursery school. We only ask employees to come in twice a week because they are sales and we feel they need to be in the office to collaborate, and have found the statistics are better in the office. So there's your proof. But the childcare issue keeps cropping up with specific individuals every week. How can we approach this? Very good question. And you're not the only one, Joe. A lot of organizations are facing this challenge.
Yeah.
And some business owners and people leaders just don't understand. They don't, only 2 days a week, and yet people still seem to have challenges. But people have got used to it, haven't they?
It's interesting, isn't it? Because as you say, people are saying only 2 days a week. What's the problem? And presumably they were previously doing 3, 4, 5 days in the office. But the flip side is employees who are saying, I've been at home for 2 years and nothing has suffered. So what is the problem with that? So you have that disconnect with people's opinions, and it's bringing together. And as you say, also doing 4-day work week. I'd love to hear more about that, Joe. Love to know how that's working.
Well, I actually spoke to Michael, who was one of the directors at their company, Easy Offices. Is it Joe? Remind me the name of your company. It's Easy Offices. I should remember that, shouldn't I? But they're actually doing 4 days, and they've offered it across the board. Flexi offices. That's it. Sorry, Joe. And it seems to be going really well. So it's half the time. It's not a lot to ask.
It's not. So I think where we are, going back to your original question, Joe, is the risk is indirect discrimination. One is always acting reasonable and all of the rest of it. But the main thrust of this is, one, flexible working requests. You have an obligation. If somebody makes a formal flexible working request, you need to follow that statutory procedure. That's fairly fixed in terms of, having a meeting, deciding the reason. And the reasons you can give, there's 8 statutory reasons, and they're pretty bland. Things like, effect on customer demand and all of that sort of thing. So it's quite easy in that way to refuse a flexible working request, as long as you tick the box of the procedure. But make sure you do tick the box of the procedure, because there can be some compensation if you don't. But the real challenge is indirect sex discrimination, particularly if the request is coming from female employees, because it is still recognised by the tribunal system, and that was confirmed again in the EAT last year. It's still recognised that women deal with primary childcare responsibility. Women mainly have primary childcare responsibilities. So any policy that requires people to go into an office however many days a week may indirectly disadvantage female workers when compared to men. Therefore, there's a potential indirect sex discrimination in your policy. Now, direct discrimination, obviously treating somebody less favourably because they're female, that's not justifiable. Indirect discrimination, which this policy may well be deemed to be, is potentially justifiable and therefore potentially lawful if you have a legitimate aim, and if your policy that you put in place is a proportionate means of achieving that legitimate aim. So you have a legitimate aim in terms of collaboration in the office. I think that's without drilling down into the facts and all of the rest of it, it's important to articulate the reason why. And I think you've considered that.
Yeah.
And then to consider is requiring everybody to be in 2 days a week a proportionate means of achieving that. So then really drilling down onto, do they really have to be there twice a week? Does that person have to be there twice a week? Maybe they only have to be in for core hours to tick that collaboration box.
Yeah.
Ultimately, it may be that you say, yes, we do really require this and it is necessary, in which case you stand firm on your policy, but that the risk you run is that discrimination challenge. But I think what you need to do is collaborate, discuss, and really articulate what and why, and consider the different options and why they're no longer viable. And that's a harder challenge given that everybody's working from home for the last 2 years, but it's not insurmountable, because I think there is also a recognition that the office culture has suffered, workplace culture has suffered. So it may well be that pinning on that. Yeah,
I mean, Joe says that their statistics prove it. And I think document everything, Joe. I go back to a case that was an estate agent, probably about 6 to 12 months ago. Time has been strange over the pandemic. And it was a lady that had asked to leave an hour early to go and pick up her children. And the employer said no. And they had to pay her 1 year salary. It was sort of £180,000, something like that. But the reason for it wasn't that saying no to that hour, that would have been lawful. It was that they didn't consider it. So it's about having that conversation, Joe, and making sure that you can demonstrate, put your business case as to why. And again, if it's you comment that actually it's working well, does have challenges, everyone wants to work from home because, like you say, nothing has changed. But all companies need to start making money and more sales, and salespeople are monitored. The monitoring, I think, might be a challenge, because you can monitor outcomes more easily from salespeople, whether it's calls or billings. So be careful about that being about monitoring. But culture and energy and all of that, you can't necessarily emulate from home.
And collaboration, what are they doing specifically that requires the in-person collaboration? So I picked up on exactly the same point you did, Meeta, in terms of monitoring, because monitoring can be done remotely. And I think something to investigate there is how you can monitor remotely to decide whether actually that becomes viable or whether it doesn't, but at least you've considered it. But interesting point that you raised, Joe, it's mainly males that are saying they have childcare issues. So the indirect discrimination risk falls away. And then you're looking at behaving as a reasonable employer. And actually, ultimately, if you force the... thank you, Joe. If you force the change, then the risk that you run as the employee has constructive unfair dismissal claim against you. But that would only be if you'd have been acting unreasonably as an employer. And if you consider everything and consult and go through that process, it's less likely that you're going to be in that scenario. But again, happy to connect offline if you'd like to.
Yeah, and Joe, no, it's not personal, because if you're facing these challenges, I guarantee you so many others will be as well. So thank you, everyone, as you're sharing your thoughts and comments. Janet, I'm sorry I missed your comment earlier. Janet, you mentioned that you have a staff member who also stated worry about COVID, anxious to come back, but then saw them, but they were then seen at a location that was packed with people and he wasn't wearing a mask. And I mean, what can someone do with that, Emma?
Well, there is an interesting case on that one where somebody had, now what were the facts specifically? It was again, somebody said, oh, I don't want to come back to work. I'm really nervous about coming into the workplace. And I think they were found in a pub, no mask. And ultimately they were dismissed for not coming back into the workplace. And the dismissal was held to be absolutely fair, because the reality is they weren't behaving consistently in such a way that would show that anxiety. But again, sorry, go on.
If an employer came across information or proof, whether it's social media or word of mouth, they could utilize that knowledge to dismiss somebody and it would be upheld. It wouldn't be seen as discrimination.
They can absolutely utilize that as part of the process. And you do get that. You often see something that's happened where somebody's been spotted out of work doing something, and it can be utilized as part of the process, and you can rely on that. I would never say it will absolutely be upheld, because you then need to drill down into the circumstances. And for example, if it's workplace anxiety, what is it about the workplace? You know, it may be that he or she was seen in a pub without a mask, but actually was sitting, 2 foot away or outside of the pub. Context is everything.
Context, that's good.
Workplace might be 100 people jammed into a relatively small space, and that the 2 people that sit opposite you have no regard for social distancing or anything else. So context is key. But absolutely, it can be brought into play as part of it. But I really, really guard against saying, I spotted them doing that outside of work, therefore they're deliberately playing the system.
Yeah. It's not that black and white.
It never is. And some of the cases that I've seen where, for example, people that suffer terribly with physical or mental health, often the doctor's advice will be go out into the park, get some fresh air, somebody suffering from anxiety and depression. One of the best things that their doctor might have told them is to go and play tennis with their friend.
Right.
Now, they're photographed playing tennis with their friend, and the employer's instinctive reaction is, oh, you can't come to work, but you can go off and do that. Well, actually, that's part of their rehabilitation. So it's all broader context, really important.
Very good advice, Emma. Thank you. And Joe, thank you. You're sharing your 4-day work week blog, which if anybody would like to have a look at, we'll share the link in the recording that goes out afterwards as well. Thank you so much for that. So time flies so quickly. We've got about 10 minutes maximum, about 7 to 10 minutes left. But Emma, I wanted to look back at the promise we had made for areas to cover. So I feel like we have covered refusing to return to work and raising COVID health-related and safety concerns. I think that's pretty much been the majority of today. In terms of misconduct and mask refusal, things like that, where are we with that with employers now? Can they make rules that have to be upheld?
Yeah, there's no legal requirements. There's no legal requirement, obviously, to wear face masks now, but it could still be a reasonable management instruction to wear masks in certain contexts, or to remain at home potentially as long as they're being paid if they're suffering COVID symptoms.
Yeah.
And if you're not following those reasonable management instructions, then there's potential disciplinaries. Again, context is important. Somebody may have a respiratory condition, which means they can't wear a mask. So in those cases, you've got to be more alive to that. But no, in general, that is absolutely still something employers can do and can stand by.
Okay. Because as you said at the start, Emma, we're not moving away. If anything, there may be a bit of an about face as this next sort of increase in cases continues. So one of the final areas I would like to cover, and you had a comment, and I thought vaccines and refusal to use vaccines and things like that. You mentioned that you don't think that's as much of a challenge now. Tell me why.
I say that purely because of the phone calls that I have been getting. So take me back 18. Well, when did the vaccination come out? Probably about a year ago, maybe. Maybe slightly more. But when it first came out, a lot of the phone calls that I received from clients were, we want vaccine passports. We want somebody to show their vaccination card. Otherwise, they're not coming into the office. And there was a lot of really strong emotion, actually, from a lot of business owners that were like, I'm not bringing somebody into my workplace unless they've had a vaccination.
Well, it polarized workplaces, because for those that weren't willing to, I mean, people were sacked from care homes, and at one point they were going to sack 80,000 NHS staff. I mean, it was extreme at one point, wasn't it?
Absolutely, and that translated down. And I think the care homes and the NHS were slightly different because they were more specific legal requirements. For example, there is still the legal requirement that the care home staff must be vaccinated, and not dismissing there is potentially fair. And there's been case law gone through to establish that. But in any other workplace, and it's the majority of workplaces where there's no legal rules around it, what has settled is you can't force somebody to have a vaccination, essentially, to keep their job, because forcing somebody to do that is not, it's too much of an invasion of privacy. And it's about reasonableness and choice. But I think also what's settled is people's attitude towards it. I think people have accepted now, and I think, as you say, it's polarized workplaces, families, friendship groups. There was Christmas, and there was a discussion about whether people would be inviting people that weren't vaccinated. I think it was Christmas before last, I can't remember which. But I think the attitudes towards it has settled. So I think now very much the advice to employers is surrounding encouragement. So when the next round of vaccinations come out, at the moment, over 75 from people that are clinically vulnerable have been invited to a fourth booster. It's personal choice, essentially, isn't it? If people take that or not, I suspect the majority of people in those categories will. When we come round to September, October, November, and they may start talking about boosters again, the right approach for employers is encouragement. Why vaccination is a good idea, why we would encourage people to do it, but no forcing of people and no segregation of people that refuse to do it. I think that's largely where that has settled into.
Good. And no cases, as far as you know, have arisen from vaccinations and things like that.
The cases arisen on vaccinations is the care home cases, where it's been fair to dismiss.
Yeah. And the final area was about, and literally we've got just a few minutes, but you mentioned that tribunals and how tribunals are actually taking place has gone on a journey of its own.
Well, I just thought it was quite interesting for anybody that's not had the misfortune of being in tribunal for the last couple of years. So previously, what we would have is some preliminary hearings. So to just decide a small procedural issue would have been by telephone, and all other hearings would have been face to face.
Yeah,
and that could mean a lot of people, their lawyers, their witnesses, travelling from one end of the country to the other. I had a case not so long ago in Scotland where I would have had 3 witnesses and a barrister going from the south of England up to Scotland for for the best part of a week. What the tribunal implemented it's called CVP, the cloud video platform, very much like Zoom, where hearings have been carried out throughout the pandemic. Even quite complicated hearings were carried out by video. And the initial impetus was because at first, when we all went into lockdown, the tribunal process ground to a halt. Yeah. And then as it became clear that this was not going to be a temporary shutdown, they needed to do something to keep the wheels of justice turning. Otherwise, the backlog would have been hideous. Yeah. And it's brilliant, the video platform, I have to say. As I say, that case that was going on in Scotland, I wouldn't have had the opportunity to observe any of it, whereas I managed to have it on in my laptop in the background whilst I was working. Right. It runs really well, and I think it's really positive. So I wouldn't be surprised if that is kept to some degree. The tribunals are very keen to get people back into in-person hearings and get people physically in front of them. Yeah. And I think that's a mixture of justice being seen to be done and perhaps judges just wanting to see the people in front of them because you get a better picture perhaps of somebody in that scenario. But I think there's a place for video to stay alongside in-person.
Another hybrid world forming, you think?
I think so. And I think what you find with the tribunal system is each tribunal or in each tribunal region can operate very differently, even though they're governed by the same rules. Yeah. They can operate quite differently. So I wouldn't be surprised if we see more use of technology in some areas rather than others. So it's a watch this space. But if you do get a tribunal hearing come through, you may find it is in person, you may find it is by video, and I wouldn't be surprised either way.
Okay, very interesting. And the theme is also very interesting, that judges need to look in the whites of people's eyes to get a measure of them. And so not surprisingly, that's kind of what's happening in the working world as well. We do need that human interaction, whether it's for connection, belonging, just really feeling part of something. And so it feels like hybrid is here to stay, even in the tribunal space as well. And the theme continues. So please, take on board the collaboration, the communication, all the C's, thinking about, creating a cohesive team through communication, you know, just making sure anything you decide, you put your business case to people, and that hopefully will protect employers and document everything.
Absolutely, first step. And if what I would say is, if you're not sure, speak to somebody, take advice before you push the button on anything, because it is so much easier for me as a lawyer to unpick something and unravel it and pull it back together again to still achieve the aim that you want to achieve before you've pushed the button on that drastic step of a dismissal or whatever it may be. It's so much easier to do that before you've pushed the button than unravel it and unpick it afterwards when it's often too late.
Yeah. Good advice, Emma. Thank you. And I think we're going to have to wind it up there. We are getting very close to we've passed the 40-minute mark, going into extra time, as they say. But I just wanted to let you all know that I'm about to publish the poll results, and mental health and wellbeing are top with 60%, and very close behind is health and safety concerns at the office. And that was based on what challenges employers and employees are facing now that restrictions have been lifted in the workplace. So we hope you found today's session useful. Thank you everyone for your input, your questions, your thoughts. And Emma, great to have you here. That was so helpful, so insightful. We really appreciate it.
My pleasure. Thank you all for collaborating and listening.
Indeed. And we look forward to hopefully seeing you again 6 weeks or so down the line.
Be my pleasure. Thank you all.
Thanks all. Bye for now.